Has nothing to do with the 23 days.
Did you turn over, hold on, one voice at a time. Did you turn over a state? I ordered you to turn over.
I'm sorry, Judge. She is not listed in the 23 days.
Not.
Sorry.
Did you turn over everything you got from the search?
Yes, Your Honor. We turned over everything. There was not a lot. We turned everything.
You got, you turned it over.
Yes.
But she's an A witness in that.
I'm sorry, Judge. She is not listed in the 23 days.
Well, you turn over everything you got from the search. Anything else?
Yes, Your Honor. We turned over everything. There was not a lot.
Just quit while you're ahead.
We turned everything over. Yes.
I'm quitting based on that.
Okay, so listen, she's an A witness. I understand.
I'm sorry, Judge. She is not listed in the 23 days.
I have no control of law enforcement continuing the investigation. That's not even my purview. What my purview is the heightened due process that's required in the first degree murder judgment. Right? This witness, Detective Luna, UNA is listed as an A witness. It doesn't matter to me what's going to happen if the state's changing their minds because they don't know what the results of the hearing. But she's like any other A witness. She has no right to refuse to answer any question.
As to an open investigation, she does. That's the state's position. She can discuss, well, then I would ask the court to conduct an in-camera hearing. Actually, I believe I have 3.22. I think the rule says the court needs to.
I mean, I probably should choose my words carefully here, but I don't really understand what frequency is. This is a death penalty.
And Judge, the heightened...
No, now it's my turn to talk. The whole purpose of this is for him to decide, and by the way, I believe I agree with there's a time, obviously. And you don't agree with it. I don't get to decide Mr. Demons gets to decide. If one of Mr. Demons' lawyers is not following the professional rules as required by the Florida bar, that would be an issue between that person and the Florida bar. And as far as the death penalty case, based on all of the very current Florida Supreme Court case law that I have cited on multiple occasions, it's his decision. Because even if there's a conflict, if he says, Judge, I want her to be my lawyer, she gets to be the lawyer. And if he says, Judge, I don't want her to be my lawyer, then she's not going to be my lawyer. That's why I had a discussion with him about this back in February. That's his decision. The reason that I had all these the search warrant and the results of what they got from the search warrant turned over, none of this should be new information. It's all coming from Ms. Liberty. At least that's what's been represented to me, so she knows what's in it.
Okay, that should be better.
What's in it, you can decide. So to that extent, the entire purpose of all of this was to make sure Mr. Demons had the correct material in front of him to make a decision. He still has to make a decision. It's not new, so it's rapidly disappearing at this point. But the bottom line is, this is an easy call today because she's an A witness. That's it. So, respectfully, over the state's objection, over the state's cited
Stream does not have captions.
You charged her with a crime. She's an A witness. She's an A witness. She has to come to the death row and answer questions just like an A witness. Your motion compels granted. Answer whatever questions you want. So I'll enter a separate order regarding that. The motion compelled Detective Christina Luna to answer questions. That's granted.
Not going to change.
And then the defense motion to compel the affidavit prepared by Detective Luna. Number one, I thought I already saw it.
No, you only saw the warrant. I don't think you've ever seen the actual affidavit, which is the public
So
policy.
I guess I'll defer on this one. Today I'll enter a separate order today. I'll give you 5 days to do a copy of the affidavit. You can look at it.
I think they're going to get to the motion for the bond
I
issue
know.
next.
You're
I
already
know
fighting
about
about
that.
this. It's 250 jurors are lining up outside the door there, so
Just so I
just
can-
use your time. If that's how you're going to use
So
it.
just so I can be clear, because we're going to provide the court with the affidavit. That's not an
The next
issue.
one.
The question that becomes is, should the court say, no, we're not turning over the affidavit, but we're taking the deposition of Detective Luna, which concerns materials contained in that affidavit, if the court's not ordering it turned over, in the state's view, she can still refuse to answer those questions because it will go to that ongoing investigation.
As authority. I understand what your position is. Listen, who decided to charge him with attempted murder? Who did that?
The 23?
Did they do that?
Yes, no. No, I mean, no, but I understand where the court's going.
Law enforcement did that, right?
Yes.
The state did that.
Yes.
Okay. So you all decided, for someone who's already facing capital charges, let's open up a new case. Let's charge him with a new crime, which can land him in prison for the rest of his life. So you're confined with the rules of discovery. I don't know what to tell you. You could have done all this the day after his murder trial was over. You could have done all this. You chose to do it when you chose to do it. So be it.
No, not the 20. So the court's clear, for the record. The 23 case has nothing to do with this Apple iCloud affidavit or with what Detective Luna potentially testified to in terms of her work in this new investigation. They have nothing to do with each other.
Courts love when you talk to me like that.
If a law enforcement officer hypothetically showed up in my door,
Education.
a search warrant on anything that belongs to any lawyer who's currently available in the death penalty case, I would decline that request and probably ask them to leave the court. Okay, so that's just my view. So those are the orders as to that. Okay. So
I hate this face so much. Oh my God.
As I did in January based on whatever. Yes, sir. Last. I have the state's motion to reconsider or order moving forward with the trial on September the 10th. This trial date remains set on September the 10th. I did that last July 8th, 2024. Although there's no motion to continue filed, I did read the motion. I guess I'll treat this as a motion to continue. I did read the authority cited therein. I did read again, Florida Statute 924-071. Additional grounds for appeal by state, time for taking and stay of cause. I likewise again reviewed the omnibus order on defendant's motion to suppress 1 through 13, which was entered by Judge Murphy on December the 20th, 2023. I also case September 2005 regarding the serious constitutional issues that are
How can I hear you talking better than
the
the
state
judge?
would be automatically entitled to stay the effect of the decision at first of the state and criminal pursuit. So, understanding that I've already looked at all of that, state, anything else that you would want to tell me in support of your motion?
No, Judge, my motion basically covers the previous court's orders, the statute, case law in terms of how this case is staying.
Okay. Defense. You all want the case to be stayed? The state says it's stayed, so do you agree with their motion? Or do you not agree with it?
Can we have one on?
Sure.
There's something else. Yeah, Drew Findling is going to be taking over, or at least becoming part of the defense team. I assume he's going to take over for Melly. I've heard rumors about that, but I confirmed it this week. He was wife and Lucci's lawyer. He's Little Dirk's lawyer in the about half a mile that way. Little Dirk case in the Central District of California. Oh. He's unhappy. Or happy? Yeah, this is live. I have no idea what's going on. I'm just trying to figure out as I go along. Yeah, I can see the live now.
Yes, sir.
Against our advice, our client wants to proceed.
Yeah, I assume we
No,
found
we
this.
reject their request that we did determine this automatic stay.
Based upon what our client has instructed us, yes, sir.
Okay, so let me make the record crystal clear on this one issue. I am aware that 924-071 calls for an automatic stay while the state is appealing some order that they want to appeal. In this particular case, which again, administrative finance duties, I'm going to ask that. Judge Murphy entered this motion to suppress, which is the subject of the appeal. He entered this order on December 20th, 2023. That was 568. And in that order, he says, at the end, the court has not been moved to consider the suppression of specific evidence. It is up to the parties to inform the court as to what specific evidence falls within the suppression order and what specific evidence is admissible.
I think that's right,
Show it
man.
to that order.
So it's hard
We
to
were
hear.
here on the defendant's renewed motion for bond on May 6th, 2065. I asked you all, had you gotten together and figured out what specific evidence falls within the suppression order? I'm going to guess that hasn't happened.
No, Judge, I made the offer to the court last time.
That's what he said last time. I'm gonna guess.
Basically, penalty phase, for lack of a better term.
No, they were aggravators. They go to membership in a gang. There are things that the jury would have to find before going into penalty.
Not aggravated as to definitely
Sorry.
aggravated as to getting that was charged. You would charge it committing the murder for the further to the gang, which is an aggravator in terms of the guilt.
Something that they would have to find by way of an interrogatory.
Yes.
Yes.
Objection, that's not.
That's not correct.
You all don't agree on it.
No, we're doing.
No, what you just said we do not agree on. Here is, I'm sorry.
Have you all done what Judge Murphy ordered you to do in
Bitch.
2023? It is up to the party to inform the court as to what specific evidence falls within the suppression order and what specific evidence is admissible.
That, may I answer the question this way?
So you're trying to
At
defend
that
a death
time,
penalty case
the
from a
state
chair?
appealed it all, which stayed everything. And so, at this point, the law on whether or not Judge Murphy was right or not is all up at the court, and it stayed. We can't determine that in a stayed case. It stayed.
You can't talk to the state and decide what this applies to.
I just argued what I had to argue, Judge.
Well,
You're saying it stayed for only one purpose,
I want you to
but
answer
not.
Shut up.
The
You're
answer
not
is
able to.
we are stayed and unable to do so.
You don't even know what evidence the order is happening.
No, I believe we do, and I think that's on appeal at the court. But during a stayed case, we cannot do those things. And that's why it hasn't been done. Not because we haven't wanted to. They appealed it. It stayed.
Unfortunately, to also remind the court, the defense did cross appeal, so even stuff that would remain in is also potentially can now be excluded should the court rule the defendant's guilty.
And that's still pending before the court.
But you don't agree with their request, you want to go forward. That's what you just told me, your client wants to go forward.
That's what he said.
Just to, if I can clarify something, our position. The
Who's this guy?
order that Judge Murphy entered kind of does not make sense. No offense to Judge Murphy, I love his rulings. But the order doesn't make sense because he did not suppress evidence. He suppressed evidence based upon a time frame. So everything before a certain date and everything after a certain date was suppressed. So I do not even understand how we could comply with that part of the order because it's everything between those dates.
You sit down with the state and make up a list, do everything out.
Happy to do something in 5
Well,
minutes.
It would take more than 5 minutes, but it can be done.
Easy.
Well, again, and Judge Murphy did this a lot longer than me, but that's what he ordered you to do, 568 days.
Which,
That's
as
what
I
he
said,
ordered you, he didn't ask you to do it, he ordered you.
fair enough.
And I brought that up 2 months ago, does anyone bother to do this? And his colleagues tell me he can't even do that, he's not allowed.
Well, I just want
You
to
do
point,
it?
What is
what I'm
she?
pointing out to the court is, it is just a time frame, it's not an individual piece of
Yeah,
evidence.
I
Drew
understand
Biden
that.
needs to
In a
show up
typical motion
immediately.
suppress,
This is
we're going to
ridiculous.
suppress the firearm that was found in the
Correct.
trunk of the car, or we're going to suppress the statement from the defendant. And usually at the end of an order granting motion to suppress, it says,
Are people
"Here's
just
the
walking
evidence."
around?
It's correct. But he didn't do that.
And I'll
And I
tell
don't
you,
have the benefit of sitting next to him when he went through all of this, so that's why he ordered you all to
and all
Say
we
what
would
it
do,
is.
and all we would be doing is reciting his order. Why can't the,
who's arguing at the court? This really is up to the who's arguing? So what if their first question is, what evidence are we talking?
Everything from this date to that date.
What date is it?
I will have that.
It's not in this.
This
Am I-
It's in the
I'm not
order.
making this up. It's in the order, Judge.
It's in the order.
There are time frames in the order. I was able to
I don't
show
know what all the evidence is. I don't know what all the exhibits are. How would I know that?
That is,
You all know that. I don't know that.
that is part of the problem that we haven't even gotten to some of the motions. When
This
we're
is
talking
amateur
about
hour. It's ridiculous.
over 2 million Instagram lines, nothing is delineated that I am suppressing line 1,287,000. All we have is a time frame, and everything within that time frame is suppressed, not anything specific. I don't know what the state's trying to introduce.
Here are the dates. I have a general idea of what the messages are. I can theoretically sit down with the each device, each return,
same thing that happened
plug
on
in the
last
dates, and it'll be like, okay, it's these 8 messages, it's these 6 messages, it's this Instagram account.
That's the only thing that was suppressed.
Essentially, yes. There's messages from Snapchat, from Instagram, from other accounts, is some other stuff I'm trying to recall.
Judge, I have a pending motion that's been pending now for well over a year, probably over 2 years now, when we're approaching that. And that is for the state to delineate what they are intending on using, because if they have 2 million lines
I think she's on the way updated.
Instagram messages,
That's what I'm hearing.
we can't be prepared for that.
I didn't
Are
think
they
she was gonna be in
introducing
this.
all 2 million? Are they introducing just some? And Ms. Buckaloo has said to me on numerous occasions, let's not hear that motion, we're not ready for it yet, because we don't know exactly what we're trying to introduce. So we have not had that heard. So I do not know what specific line the state wants to introduce that would be suppressed by that order, because they have not told us. So all I am left with is that sole period of time. I have nothing else I can say. I can say every Instagram from such and such a date to this date, because I do not know what they're intending on using.
Okay, so in Judge Murphy's order that denied the defense motion, so it's actually quoted numerous Florida cases for as follows. Although a trial court may vacate an automatic stay during the pendency of an appeal, it may do so only under the most compelling circumstances. Party moving to vacate an automatic stay must demonstrate that the equities are overwhelmingly tilted against maintaining the stay. In determining whether to vacate an automatic stay, the trial court must consider the government's likelihood of success on appeal and the likelihood of irreparable harm if the automatic stay is reinstated. I'm also going to quote Mitchell, which Jimmy writes to. That's from the Florida Supreme Court. Ordinarily, there are 2 principal considerations that courts must take into account when deciding whether to vacate a stay. The likelihood of irreparable harm if the stay is not granted, and the likelihood of success on the merits by the entity seeking to maintain the stay. That's the state. These stays are subject to the discretion of the trial court to dissolve or modify based upon the important interests of the parties and the particular circumstances of each case. Lastly, I think I'm repeating myself in the hearing today. They recognize a special exemption in criminal cases. This exemption is directly related to the serious constitutional issues that will be implicated if the state would be automatically entitled to stay the effective decision adverse to the state in criminal proceedings. So, I'm only supposed to vacate these states, which the case also has the authority to do under the most compelling of circumstances. I do find in this case to be under the most compelling of circumstances. Mr. Chairman, as I sit here today, we've been invested for 2,300. A special set of case was filed on September 10th. I did that back on July 8th, 2024. Over a year, 367 days. this division that I took over from Judge Murphy, FT trial board, was created specifically for the purpose of trying long jury trials for people that were in custody for a long period of time, to prevent exactly what has happened with Devin from happening. Besides Mr. Devin's cases, which I've removed, this division currently has 38 other cases, special set for trial. 22 of those are murder cases. Numerous of those are death penalty cases. Right now, this division has trial special set for December 2020. Any new trial dates I get out will be starting in 2022. I have reserved the entire balance of September, the entire month of October, to try Mr. Denny's case, Mr. Henry's case. If the defense doesn't object over the state's objection, we are going to go forward on September. The state's motion to reconsider oral order moving forward with the September 10th, 2025 trial date is going to be denied. I will enter the appropriate written order. Next, I'm starting a capital case tomorrow. The only thing that's going to interfere with the September 10th date is if we happen to be in penalty first in that case. I don't know if that's going to happen. But what I can tell both parties, and you all can write these dates down, I'm going to give you every available day, every available minute that I have between now and September the 10th. Do whatever it is you decide to take me. On Monday, August the 18th, I have from 9 o'clock to 12:30 and from 1:45 to 5 o'clock. That's the entire day. The normal 12:30 to 1:45. On Tuesday, August the 19th, I have from 9 o'clock in the morning to 12 noon.
What was the hours on the 18th? I'm sorry.
9 o'clock to 12:30 and 1:45 to 5 o'clock. The next day, which is Tuesday, August 19th, I have 9 o'clock to 12 noon. Again, the only thing that would interfere with those is if I happen to be in a penalty proceeding in the trial that's starting. I then have September the 5th, from 9 o'clock to 12:30, and 1:45 to 5 o'clock, the entire day. Tuesday, September the 9th, from 9 o'clock to 12:30. So the grand total of those dates and times that I just told you is 20 hours. I'm not going to set anything else.
They do sometimes.
You may use that as you see fit.
That's your Nene's question. I'll get to that.
I'll tell you that when you start screening jurors for dates,
And I apologize, Your Honor. I have the 8/18 and 8/19. I missed the other dates. I was
September the 5th, that's a Friday, 9 o'clock to 12:30, and 1:45 to 5 o'clock on September the 9th. 9 o'clock to 12:30.
If I can, just for purposes of the record, because I know the court has cited that the defendant has been in custody for a long period of time, just to bring, for the record, for the court's attention, the defendant has already had one completed jury trial during this time period, which was in this trial. A second trial was started, and a continuance was taken during jury selection because of the difficulties we will have with the seating a jury in that case. So he has had those opportunities for trial. In addition, the state did take an appeal. The defense also did take a cross appeal. So when the court talks about the overwhelming issue and compelling the state to go forward, I don't know if the court is considering the fact that the defense, by filing its own cross appeal, it's also created a delay. And if he's insisting on going to trial, is he now waiving that appeal, seeking a suppression of additional evidence? And finally, Judge, just so again the record's clear, what this, given Judge Murphy's order, and there would be an intent to comply with it, what the court is compelling the state to do is to go forward with evidence that has been suppressed. In other words, we would not be able to use that evidence.
Yeah. It's suppressed. That's exactly right. Listen, I have to follow orders from higher court. Well, plenty of times, from what I've told you right now. If someone
Yes.
goes up to the court PCA and asks them for a stay, and they send me an order that says it's stay, I'll do all these things. You all can figure all that out on the West Palm Beach.
And that's a conversation we'll be having, Judge. With the court's indulgence, just one other issue, going back to the
You are correct.
order compelling Detective Luna to testify, answer questions. What we would ask the court to do is just briefly, in camera, with the court reporter, just take brief testimony that it is an open investigation. We just need that clarity so that when we discuss it with the AG, since it'll be testimony as opposed to my proffer.
She's
I
not
understand.
more than on that.
I mean, if you don't like what happened in court, you change it. I mean, you all have an ethical obligation of the rule.
For a testimony as it relates to his homicide case, but we're going to go into another area, and that's where we'd be seeking that protection with the in-camera review of the open investigation.
How do you know the questions?
Well, they proffered some of them, and I understand how it's like to be the defense attorney. I kind of know where they're going to go, Judge.
Okay, that request respectfully is denied.
So for just clarity, you're refusing an in-camera hearing for the open the fact that it's an open investigation.
You want me to bring a witness, in what, in the jury room, outside of the presence of the public?
Yes.
With a court reporter.
With a court reporter. With a court reporter. This is the guidelines that are outlined under Rule 3220. The court so the court is aware to create a record that there's an open investigation.
This is ridiculous.
And I want that clarity for the fourth when they ask, is it
I don't
official?
believe that there is. What they argue is correct. I said that in January. Back when I was doing this, standing out there, it didn't take me 18 months to arrest my client. It took me about 18 minutes. So
I can show you the investigation. Opinion. That's the point of why I'm asking, just for purposes of record.
How long would that last? Now, I'm not going to argue. You're telling me this could be ad infinitum. This could be for any indefinite period of
I
time.
can discuss that with the court in camera, how long the investigation is going to take, but I'm not prepared to do
You don't
it.
have an investigation.
No, but law enforcement gets to decide that. That's your business. They just get to decide.
Well, it's also dictated by when and how evidence is received, where it leads, how long it takes to get that information, how long it takes to interview those witnesses, et cetera, et cetera.
They've got to take homicide detectives or anything else.
It's about 6 years.
I mean, are you kidding me? You could circumvent the globe, maybe. It's like evidence when you leave. That request is, I mean, you didn't file a motion. You're making this oral. In case you want to have.
Well, no, it was part of my original motion to have an in-camera hearing. That was in my motion. That was in there.
That was part of your response.
Yes.
It is yours.
Yes, that we were requesting the in-camera hearing. If the
So you
court,
already did it, right? So, yeah, your request for an in-camera hearing, respectfully. She's a witness. I don't understand what she's a witness. You listed her as a witness, right?
It's about 20 minutes, so you're on the court file.
Well, who did it when we started the case? Who listed her as an, I mean, you want to do this for, who listed her as an witness? They didn't.
I don't know who actually.
Somebody did.
Yes.
Someone from the state attorney's office signed their name and said, this person has personal knowledge about this case, right?
Yes.
Okay. So the rules are the same here in any other circuit or county court. Your request is denied. I'll stand on the reasons why. State, anything else I can do for you today?
One more.
They asked for a no.
Oh, I'm sorry.
We're trying to make sure of that.
It seems like they're not going to get to the motion to reconsider the motion for bonds. I wonder if that's what Melly's upset about. Unless they already did it, I just missed the start.
And I think we should probably. Defense, anything else I can do for you to say?
You
How would
can
you
dismiss
plan
the
on-
charges against it, but I don't think you go.
Anything else?
No.
No, sure. Okay, so as of right now, Mr. Jennings does have a court date I noticed next week on the tampering case, and the status date. We want to just handle that right now. So you're going to hear right now. All right, so this is in 23-10593 CF10A. Mr. Jennings is wrote, Mr. Henry is wrote, Mr. Mathis is set for status, what we call the counter call or status for trial. Next, Wednesday, July 16th, so I'll get this court is hearing right now.
And you come in for this and figure out it.
I think he filed
You do
that
it
up here
by
via
Zoom,
Zoom
so
next
you
week.
Yes.
I don't want to.
I just spoke to Mr.
All right,
Haddad.
so listen,
Okay.
Ms. Liberty, I also have this case set for trial September the 10th, the same day, obviously, set for trial, and
So in light of the court's ruling on the homicide, I would just orderly renew my motion to lift the stay so we can argue the C4 motion, Judge.
I'm going forward. I'm ready to argue your easy one.
Okay, so I will set the C4 motion for one of those dates that you gave me, Judge. Thank you. Great.
So Ms. Wilcox, you believe this is going to be signed on July 16th. He remains set for trial in that case. The case is not open until the 23rd.
Try to work thing. I gotta minimize this real quick.
For the record, I know what the court's looking. For the record, state raised the same issue in its motion. It's automatically stayed. Judge Murphy also entered a stay. In the case, it's the same evidence that has actually been suppressed that we were intending to use in the tampering case. So same arguments that I made on the 19 case in terms of how the stay should remain in place, the automatic stay should not be listed. The state would be compelled to go to trial with evidence that had, or without the evidence that had been suppressed. And we're asking the stay to remain in place. Or the stay is automatically should remain in place.
Yes, over your objection. The state ruling that that case is over the same compelling reasons that I've already thrown record in 19.872 CF.
Thank you.
State, you need the affidavit.
We're going to talk to the AG, Your Honor, but once we make that determination, we'll either advise the court as to what's going on, or we'll turn it over.
Judge, will you give up a time limit?
You said 5 days.
5 days.
Yeah, you said 5 days.
I didn't hear you. Thank you.
Okay.
Thank you, Your Honor.
Thank you.
Have a good day. Ms. Wilcox is otherwise okay. So that means otherwise we'll be in recess until tomorrow, which is Thursday, July 10th.
He's still talking. Is that your boys? Or peace line, brother. That's peace line.
Good side. Of course I do.
Everybody else do it.
There's two of them.
Yeah, I think I missed the first part of this of the hearing. I forgot it was going live today. Let's see. This guy is that? Yeah, I think that's B Slime. Not YSL B Slime, the other B Slime. YNW B Slime. Oh god, there he is. That was a mess. Nene, I honestly don't know. I know for a fact that they hired Drew Findling. Melly's team hired Drew Findling. I don't know if he's going to be taking over entirely or if he's just going to be a part of the team. I have to imagine that he's going to be taking over entirely. Sorry about that. But I can't say for sure. But certainly I imagine that, yeah, no, I imagine he's going to be taking over entirely. I do know that, I mean, the judge kept the trial slated for September 10th, which I'm kind of surprised by. It seems like it's inevitably going to be pushed anyway, but we'll see about that. But yeah. I'm probably going to go offline now. I wasn't even planning on doing the stream, but I saw that it was live and I decided to jump on. But I'll definitely be doing the next one. I'm really interested to see what happens with the motion to reconsider the denial of the second motion for bond. That's kind of something I've spent some time looking into, rather than this motion to suppress and the motion to reschedule that was heard today. Like I said, I still do believe that the trial will get rescheduled. I think the judge is just trying to push back for as long as possible, but we'll see. But yeah, thanks for streaming, for tuning in, everybody. I might do another live stream later. I was actually working on preparing something, as you can see here for my stream later, or for a video later. But yeah, I don't know yet. We'll see. I'll tweet out in advance either way. But yeah, thanks for